question I get pretty much every day is, should I waive my preliminary hearing? And the answer is, like many of the answers to the questions I answer on this channel, it depends. I'm Josh Camson. I'm a criminal defense attorney with Miller, Turetsky, Rule McLennan. I help people fight their criminal cases so they can put it behind them and move on with their lives. Today we're talking about preliminary hearings. Hopefully you've seen my other videos on what is a preliminary hearing and should you testify at a preliminary hearing. But one of the main questions is, should I waive my preliminary hearing? You know, a lot of times you get there, you get to the magistrate's office or central court, depending on what county you're in, and the prosecutor or the officer, if there's no prosecutor, says, oh, you can waive this. Just waive it up to court. We'll deal with it at common pleas. We'll deal with it downtown. We'll deal with it at the county seat. Seems easy enough. You fill out a little paperwork. You don't have to sit around all day waiting for your case to be called, and then you fight it at the next level. What are you giving up? The judge will explain to you, and the forms will explain to you, you're not giving up all of your rights. It's not a are you guilty or are you innocent situation, but you are giving up your right to cross-examine witnesses, you're giving up your right to see the evidence against you, and you're giving up your right to challenge the evidence without a trial. So that means if you waive your preliminary hearing, you can't file a petition for writ of habeas corpus to challenge that these facts don't match the law. In other words, even assuming everything's true, it just doesn't match up. And that happens all the time. So you got to be careful when you're waiving the preliminary hearing. And what I always tell clients is there's only a few situations where I think it's okay to waive a preliminary hearing. The number one and the most important is in exchange for a bail reduction. So if somebody's incarcerated and the Commonwealth, the prosecutor, is willing to agree to a lower bail so that person can get out of jail in exchange for waiving a preliminary hearing, usually a pretty good situation. Unless the case is very, very, very weak, you're not going to get it dismissed at a preliminary hearing anyway. So you're better off getting out of jail, fighting the case from the street. That's the first situation. Second situation is ARD. A lot of counties require that if you're going to apply for ARD, and we have a separate video on what that is, but if you're going to apply for ARD, you have to waive the preliminary hearing. So if your case is going to be ARD eligible, that's a no-brainer. Third situation is when they're going to withdraw charges. In other words, sometimes the Commonwealth looks at what the police wrote down, how they filed it, they look at the form and the complaint, and they say, this is a little overcharged. They're not going to admit that, but they might be willing to drop some of the lead, more serious charges in exchange for a waiver. So we can fight a misdemeanor 2 instead of a misdemeanor 1, or a felony 2 instead of a felony 1, although that never happens. But whatever it is, if you can get a more serious charge dismissed in exchange for a waiver, that's sometimes worth it. But if the whole case is BS anyway, then maybe it's not worth it. And if those charges are so weak that they're not going to get held over anyway, again, maybe not worth it. So these are the things to take into consideration. Now, the other area that prosecutors like to talk about is consideration. Oh, if you waive this preliminary hearing, we'll give you consideration when we make a plea offer. Does it happen? Yes. Can you trust every prosecutor that says they're going to do it? No. Do I always make a memo to my file that this was what was discussed at the preliminary hearing if there was a discussion of consideration? Absolutely. And most counties won't let you do a fast track plea where they'll actually put a plea agreement in writing. But if a prosecutor tells you something specific, like, hey, if you waive it, I'm going to make an offer for probation. Or if you waive it, I'm going to make an offer for county time instead of state time. Usually that's better than if you waive your prelim, we'll take it into consideration. I don't like taking it into consideration. I've waived cases for that reason before. Usually if it's a sex case, a minor victim, meaning a kid victim, that is something we can argue at sentencing, like we didn't make this person testify, client took responsibility, if it's that kind of case. So you really have to weigh the options. You know, the benefit of a preliminary hearing is you get to lock someone in on their testimony. So especially in like a domestic or a he said, she said, or an assault case, we get to lock in that testimony, get a recording of it, so that later if that testimony changes, we've got that prior and consistent statement. And that's something that is a valuable tool in the toolbox for trial advocacy. But if it's the kind of case where there's not a ton in dispute and the argument is, well, you know, is it really a legal issue? That's something to consider. And then the other piece is, if it's going to be a plea anyway, you can waive it and use that for negotiation down the road. So it's very, very fact specific and very, very specific to your case, which is why you should hire a good looking lawyer. I'm not saying me. I'm not saying I'm good looking. My wife says that sometimes, not all the time. But definitely think about it. It's a serious consideration. Again, I'm Josh Camson. I'm a criminal defense attorney with Miller, Turetsky, Rule McLennan. If you found this video valuable, share it, hit the subscribe button. We got a lot of content coming out that I hope you enjoy. Thanks a lot.